how right to information is becoming right to deny information, why it affects the basic fundamentals of democracy, and what are the provisions that need to be understood and challenged. Very few of you might have noticed, but a quiet amendment has changed the soul of India's key transparency law. The Digital Personal Data Protection Act has altered some key provisions of the RTI Act, which are changing the scales between privacy and accountability. And this has far-reaching consequences that you should be aware about. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and today we are going to talk about the DPDP Act and the RTI Act of 2005 and how the amendment of RTI Act has led to far-reaching consequences that we all should be aware about. So if we talk about the original RTI Act of 2025, it was considered, and it still is considered, as a milestone in transparency and how it changed our governance towards a participatory democracy, as well as it strengthened our accountability. This also provided empowerment to the citizens because they were allowed to access the government held information. यहाँ पे जो चेंज आया आरटीआई से वो ये था कि यहाँ पे सिटीजन्स जो हैं वो अपनी ही डेमोक्रेसी में जो उनके लिए बनाई गई है उसके बारे में ज़्यादा इंफॉर्मेशन ले पाएंगे और बेहतर तरीके से कंट्रीब्यूट कर पाएंगे. एंड दैट इज़ वाई यहाँ पे जो गवर्नेंस का तरीका था उसके लिए, उसके चेंज के लिए इसको एक रिमार्केबल माइलस्टोन एक्ट जो है माना जाता है. However, इसमें भी कुछ exceptions है. There were certain exceptions in this particular act as well, and these exceptions were catered by Section 8. Now, what did the Section 8 talk about? Section 8 talked about the key exemptions that were made in the RTI Act. That means in what scenarios the information would not be given to the citizens. So it included multiple provisions. For example, if any information harms the national interest. It also included any information which is confidential based on fiduciary relationships, or it breaches privilege, or it discloses the commercial confidential information. All of these were very important, but the protection came from the fact that especially Section 8 Clause 1J protected the personal information, but there was an exemption to this also कि अगर पब्लिक इंफॉर्मेशन बनने से रोकना है पर्सनल इंफॉर्मेशन को तो कुछ केसेस में जो है डिस्क्लोजर अलाउड नहीं था, बट कुछ केसेस में डिस्क्लोजर अलाउड था. वो कौन से केसेस थे जिसमें डिस्क्लोजर अलाउड था? देयर वर सर्टेन केसेस इन विच डिस्क्लोजर वाज अलाउड even if it was a personal information, and that was specifically mentioned. For example, if the information had connection with public activity, even if it was a personal information, it could be disclosed. Or if it served the larger public interest and that was justified with the disclosure, then also the personal information could be disclosed. Now, as per the provisions, there was a proper acid test also given to understand if the information should be disclosed or not. Now, what was that proviso or the acid test? So, when we talk about that particular proviso, the fundamental basis of that was, can that information be denied to parliament or state legislature? If that information is not being given to parliament or state legislature, that means it cannot be disclosed. But if it can be provided to the parliament or the state legislature, that means it can be given to a citizen as well. And this acid test also helped in disclosing the information, and it formed a balancing act in understanding where the right to information should be stopped so as to ensure the bigger interests or national interest or the confidential information. Now, this provided a direct balance between right to know as well as right to privacy. That means what citizens need to know and the right to privacy that can be exercised by individual firms, companies, government, etc. Now come to the alteration that we are talking about. This act, which was hailed for its transparency, changing the way of governance, came an amendment to it through the DPDP Act. When we talk about DPDP Act, that is Digital Personal Data Protection Act, and before this, as I said, the old RTI allowed the denial of information only if it was unrelated to public activity or it could cause an unwarranted provision of privacy, and there was an acid test given to that as well. But after the amendment, because of the DPDP Act of 2023, this RTI changed to right to deny information. Let us understand why. Now, through the amendment, there was a provision which only states that information which relates to personal information cannot be disclosed. As simple as that. There was no other detailing given out, no other explanations, no tests were provided, no public activity, larger interest, unwarranted invasion, no explanation, no detailing. It just said any information which is personal information will not be disclosed, and this DPDP Act was responsible for amendment of section 8 of the RTI Act. Now, in this particular act, DPDP Act of 2023, it also defines person. Now, what is a person? It will broadly include almost everything. It includes individuals, companies, firms, association, even the state is included in here. That means DPDP has given a supremacy clause जहाँ पे किसी भी केस में अगर किसी तरीके का कॉन्फ्लिक्ट होता है बाकी लॉज से, तो ये जो यहाँ पे एक्ट में प्रोविजन है वो सुपरसीड करेगा. सो DPDP gives a supremacy clause. That means this particular statement, this provision will prevail even if there is a conflict with other laws. So there is a change which gives a whitewash where there is no clarity, no ambiguity. Your information can be denied based on the fact that it relates to some personal info, and then the protection stands in the name of supremacy clause where there is a conflict with any other law, this particular law prevails over it. Now, to give you more insight into it, let us understand that what are the practical impacts that we all need to understand. The first one being that it directly vastly expands what can be termed as personal. In the original section 8(1)(j), it was detailed what is personal. It had proper explanation in 46 words. But if we talked about the amended section, it has only 6 words, which we just saw here, that information which relates to personal information, which gives us no clarity, gives us no explanation what can mean as personal information. And second, in the original section, we had the provision of public activity, unwarranted invasion test. In such scenarios, exceptions can be made, and it also had the proviso of acid test. But in this case, there is nothing and none. So this will directly impact the government records such as, let's just say, contracts, tenders, any sort of bid evaluations, payrolls, attendance, ghost employee data. Let's just say a government employee is not present at his desk and you file an RTI because that it's his personal information, it will not be disclosed to you based on this. Any sorts of minutes of the meeting or sanction orders, they can be simply withheld because they are classified, or they can be classified or labeled as personal. So this gives the PIOs what? A ready-made escape hatch so that they can easily reject your request when they go for RTI. So this clearly provides the public information officers a way to escape. यहाँ पे public information officers जो हैं, because वो label कर सकते हैं इन सभी चीज़ों का या इन जैसी चीज़ों को as personal, they are not obligated to give you information, and this will make them easier for them to reject any sorts of request from your end. Now, इसका impact क्या होगा in terms of governance or accountability? When we are talking about the implications for governance and accountability, you have to remember the original RTI talked about accountability and transparency, and this amendment is actually altering that because it will be shielding corruption as well as maladministration. For example, if there is any sort of info on fake beneficiaries, shell vendors who do not exist, or irregular tenders, they will never come to the surface. or there are investigations related to welfare scams, ghost employees, they will be very difficult to be found. This will also lead to a fear factor, especially in public information officers, because as per the amendment, DPDP imposes penalties of up to rupees 250 crores if there is any wrongful disclosure. So a public information officer who discloses any sort of wrong information would be penalized for this huge amount. Obviously, he will consider it safer to be risk-free where he does not have to disclose any information. In such scenarios, it will be always safer to deny than to actually sit there and pay for the fine. That will automatically lead to disclosure culture collapse. That means the information will mostly not come out. Furthermore, apart from these two implications, another important one is the fact that it will directly lead to collapse of the public interest. That it will lead to the collapse of public interest override. So if you talk about the original RTI section 8 clause 1J, it allowed disclosure in certain cases if there was larger public interest outweighing the harm. If harm is lesser, public interest is bigger, in such cases there will be disclosure of information. However, this was rarely used, but now because of this change that has been made, amendment because of DPDP Act, there is no such provision that is available, and it is further hardened because there is a penalty risk on the public information officers as well. And last and the finality, which all of you and me should know, is that our right as a citizen and the media oversight is being eroded. RTI's success was dependent on the fact that ordinary citizens and journalists could access the information. They were sitting as watchdogs and they could understand and explain. And this amendment going unnoticed is something that is very problematic, because if the data remains sealed off, the scrutiny becomes lesser and lesser. This will directly lead to more corruption, and inefficiency will gradually thrive in governance, which we do not want, especially when we are aiming to become a $5 trillion economy. We want to be a developed country. It cannot work on such ethics and the threat of corruption looming at every corner of the government working. Now the question is, what can be done? This is what is going on that needs to be known by you. What can be done? If we talk about the way forward from here, the first thing that is required is awareness. We need to talk about it. Public debate on the impact, that what are these amendments are going to do. Let me know in the comment section where you think what are the actual consequences of these amendments. Furthermore, there needs to be more clear rules and guidelines so that the personal information part can be understood, and public interest test needs to be restored as well. For example, if we are talking about political parties, include protection in RTI manifestos. That means the awareness at public end, we need to demand that political parties need to include protection of RTI, otherwise the whole idea of transparent governance as well as participatory democracy seems to be compromised. Then there needs to be strengthening of training and legal support, especially for PIOs, because they are the main point of contact. Because if they will be driven by fears, then the requests for RTI will see huge number of rejections in coming time, and again limiting our ways to get the information that we deserve to know as citizens. Now this is the time where media and civil society must sensitize people, must make them aware that data privacy is not equal to blanket secrecy by the government. What are your views on this? Let me know in the comment section. That was all from my side. Thank you so much.